My name's Kylie Beckhouse. I'm the Director
And if you could speak up.
Yeah, I might just move a bit closer. Director of Family Law Services at Legal Aid New South Wales. That remit involves administration and management of child protection services, which are state-funded, family law services, which are predominantly Commonwealth-funded, as well as a family dispute resolution service. I wanted to begin by giving an indication of the way that the scope of services provided by Legal Aid New South Wales, and also to give you some perspective on the way that we manage the delivery of those services in a family law environment. If we depicted it graphically, it would be like a triangle with the most services being what we'd call information services, and they're some of the services that has just been discussed by Law Access. We then go to advice services. At the moment, I think in the last financial year, there were about 29,000 of those services in family law delivered across New South Wales. Those advice services are not just delivered from legal aid offices. We do deliver them from about, I think, 23 legal aid offices across New South Wales, but we also deliver those services at 168 outreach locations across New South Wales. There's a lot of thought that goes into the locations at which those services are delivered. The majority of the locations are actually in regional and rural areas. We have a network called the Combined Legal Service Delivery Network, and that exists across New South Wales, where all of the legal service providers get together to identify where the gaps are in legal services. So often as a result of those forums, we will be minded to commence new services in order to meet legal needs. So it's very much an evolving area. In the last 12 months, for example, Moree has seen an increase in family law services and a CLSD network has been formed there. So it's quite a fluid approach to delivering services. I heard earlier the comments of Helen Campbell from Women's Legal Service in relation to the impact of a decrease in funding, and again, it would often be the case that when outreaches have to be closed due to funding by one agency, that legal aid would then consider whether we would go in to provide those services by way of a backup. And that's in many ways why I say in terms of a triangle, the advice services are quite significant, because we do have a broad reach in terms of those services. There's also been talk this morning about different types of outreach locations, and I suppose I just wanted to also identify that that's actually been quite an important part of the strategy of the legal assistance sector in terms of meeting the needs of the most disadvantaged. So increasingly we're delivering services in outreach locations like migrant resource centres. We deliver, I think, services in about 11 migrant resource centres across New South Wales. There's been talk about health justice partnerships. Certainly that's also a focus of our services. We just introduced a service in Blacktown Hospital, for example, and it's an increasing area of interest, I think, across the legal assistance sector, because we're becoming a lot wiser, I suppose, in terms of targeting services at a location that best meets demand for those very disadvantaged clients. Following on from advice, we provide minor assistance. Minor assistance services are done without a grant of legal aid. So in that pyramid, we're still talking a general eligibility for the whole of the community to any of those services. They're not means-tested services. And then following on from that, we provide duty services in family law registries, in all family law registries across New South Wales. We provide some domestic violence services in local courts, and we also fund private practitioners to provide legal services, and community legal centres obviously provide services in local courts in domestic violence lists. Though following on from duty, we then means test our services, and they're the casework services. So again, in terms of the pyramid, we're down to the pointy end. And if we were going to look at expenditure, we might well invert that pyramid, because in fact the casework services are often the most expensive of all of the services we provide. In the last financial year, we provided grants of aid in approximately 11,000 matters. In family law, this is. The vast majority of those services are actually provided by the private profession, notwithstanding that Legal Aid New South Wales does provide casework services in about 20 locations across New South Wales. The vast majority of our casework services are still provided by private practitioners under a grant of legal aid. In terms of the grants of legal aid, I thought I'd just sort of give you a bit of a breakdown or indicator of what sort of matters we're talking about in a family law sense. The biggest area for us is family dispute resolution. Family dispute resolution that we offer at Legal Aid New South Wales is a lawyer-assisted model. That means that one party must be eligible for a grant of legal assistance, and that then entitles them to attend a mediation with a legal representative. The mediator is not necessarily legally trained. That particular service at Legal Aid last year conducted over 2,700 mediations, and each of those mediations is 3 hours in duration. So it's a very big service. I give you that figure to give you some indication of the amount of triaging and intervention that actually is provided, because as part of our grant of legal aid structure, unless there is an exemption from mediation requirements, and there are good reasons why we wouldn't require people to go through a mediation, but generally speaking, that is the first type of legal assistance in a case representation sense that people would be entitled to through a mediation. And then layered on top of that, once we have granted legal aid for case representation, we generally will not fund a matter proceeding to a final hearing until they have had what we call a litigation intervention mediation. So they're sent back again to have another attempt at that mediation, and that mediation is normally done with the assistance of an expert report that might be available at that time. That program runs at a success rate that is very high. So last year I think the success rate was 79%. Now, when I talk success, so let's be clear, it doesn't necessarily mean a full resolution of all outstanding matters, but it does mean a resolution of at least some matters, a partial resolution.
And by that, do you mean keeping them out of court where there's been full resolution?
Yeah, absolutely. I think that they're kept out of court in well, actually, I won't give you, I can't be clear on exactly the statistic. We run a program in Parramatta and Sydney registries called the Court Ordered Mediation Program. So that's a mediation system that is embedded as part of the court process, and one of the parties must have a grant of legal aid to participate. That program often deals with matters that have gone through the court system without a mediation, and often they do because there are urgent circumstances that require people to file in court rather quickly, but again they're referred back out to that mediation program. There's also a settlement service that's provided by the Law Society of New South Wales for family law matters in the Sydney registry. So both of those systems are available to litigants. I suppose I give you that information because it's indicative of the attempts that are made to appropriately triage and refer matters for resolution to take some burden off an overburdened court system.
Does it follow then that the more resources that are put into the mediation service, a triaging service, the fewer matters that would actually find their way into the court system?
Yes, absolutely.
Is there a correlation between
the two? Yes, there absolutely is. We had the Law and Justice Foundation do an assessment of our services in Parramatta in 2011, and they were able to identify a number of court days that were saved, and also a number of litigants that turned up at that court registry that didn't need to be there. And we also understand from legal needs, and the Law and Justice Foundation have done a lot of work on the legal needs of people and where they turn for assistance. And we know that people turn to the family court as an institution. If there's a family law problem, you've got to go to the court. Now, that actually isn't the legislative pathway, and we know as legal practitioners that's not actually where you'd send people, but notwithstanding that, there is a community perception that it's an entry point, and it certainly is an entry point. So we very much support and commit resources to what we call triaging people at the door of the court. So when people arrive, often they're self-represented litigants wanting to file documents, we ensure that legal services are available at that point in time to try and assist in the management of those matters at a very early point, and we find it's a very effective tool for us and has certainly saved us money in terms of the administration of our own limited bucket of funds.
And who fills that bucket?
Well, that is the National Partnerships Agreement is the Commonwealth bucket, I suppose. So for the family law program, that's the Commonwealth funded program.
And what is happening to that program from July next year? Is there going to be a reduction of funds for family law matters?
Yeah, that's right. So in real terms for Legal Aid New South Wales, we in the term of our new National Partnerships Agreement, and I say new at 2015 was the year, in real terms it's about a $16 million hit over a 4-year period of time.
And what will that mean for services that you provide?
Well, it obviously means that less services are available. Because we're a very large organisation and we have the largest reach of any legal assistance agency, we don't take a shut the door approach. We can't take a shut the door approach. So we tend to go back to that pyramid approach. We know that litigation services are the services that cost the most money. So we might turn the taps off certain categories of eligibility, for example, to manage our funds better. We might look at whether people come back and have 2 mediations rather than 1. Now, I don't make those decisions. We have a board, I have a CEO, but that's the sort of thinking that goes into how you manage those services. We try not to take those services away at that really broad end in terms of advice and minor assistance and duty, and we don't because we fundamentally believe that if you don't have the triaging taking place and the appropriate intervention early on, it ultimately will cost us much more in the back end of litigation.
You've spoken mainly about legal aid for family law matters. What about other matters?
Well, the civil law program is heavily reliant as well on that bucket of money. In fact, the Productivity Commission did find that there was a major injection of funds that was necessary in order to support those sorts of programs. There's an important reason for it, because what we now understand about legal needs is that for 9% of the people with legal problems, they actually constitute about 65% of the legal problems. So it's a correlation of people who have a lot of issues. Now, my area obviously is the family law jurisdiction, and I've just finished a term on the Family Law Council of Australia, and our reference, which is currently with the Attorney General, so I can't say too much about what will be in the report, but the reference there was on the complex needs of families who use the family law system. And I think that Judge Scarlett very much referred to this group of people who are complex. They have really complex needs. And I think there's still a community perception that people who use family law courts are relatively uncomplicated people, that they're arguing about the number of nights a child will spend with a parent. But the reality for family law courts is that those matters are all dealt with by the triaging I've referred to, by the mediation with all those high success rates, and you end up with a group of people who have more than one problem. just on our own figures alone in terms of the legal aid in-house practice, 3 out of 4 of our matters have allegations of family violence. And there will then be on top of that allegations of mental health, drug and alcohol issues as an example. So they're a very complex group. Add to that mix court delays where matters are not being dealt with for 2 or 3 years, and I'd suggest that there's some real societal dangers there with that group of people.
Can you just expand on that, on the societal dangers that you're talking about because of the delays?
So there are matters coming into the court with a lot of risk factors. There are not sufficient services to adequately unpack at a very early stage what those risk factors are. We would argue, as a lot of community legal centres would argue, and a lot of people in the community, that risk assessment for any family going into the family law environment is absolutely critical, followed by safety planning. But basic services like those aren't necessarily available at an early point in time. And that means that you have children where there are allegations of risk that are not being determined by courts because there are not the judicial resources to make those determinations, and sometimes those matters or those determinations about risk can't be made for at least 3 years. And whilst that happens, there are children who are either in homes where they are exposed to dangers, or their relationship with a parent is interrupted or disrupted whilst we wait for courts to have the resources to deal with those families.
Sorry, Judge, and beg my pardon for my voice, but Judge Scarlett indicated that there was an increase in funding in relation to registrars, that they could deal with issues. Is that something a registrar could deal with, deciding what cases held high risk factors?
Look, I don't think there's any one solution. I heard that, and I think that any resources are a good thing. They might be family consultants who are able to do risk assessments in every matter. Certainly registrars who can deal with parties at a very early stage and make some directions about the way that a matter should proceed or could proceed would certainly be helpful. But we could even look at the Family Law Act and say it's a very complicated piece of legislation. And when I watch judges have to make even interim determinations, that process itself takes an incredibly long period of time because of the complexity of the legislation. So you imagine how a self-represented litigant navigates that system, and we're not surprised, I suppose, that people become very frustrated about the system and how it meets their needs.
If I can just take you back to mediation, my understanding is that mediation is not mandatory in family law matters, is it?
Well, no, it is to a certain extent. There are pre-action procedures that are referred to in the Family Law Act and the rules, and a certificate is required to be filed by parties when they commence proceedings to indicate either that they've participated in mediation or that there are exemptions that apply. So no, it's mandatory to that extent.
Okay. And just one further question, if I may. You indicated that there was 11,000 grants approved. Do you know how many applications weren't approved?
I can't give you a precise number, but I'm happy to provide that to the committee. It's a public number, and it's in our annual report each year, so I'm happy to pass that on.